I've been working on my contracts outline for the past 5 hours. So welcome to my TikTok series explaining contracts for the people who want to learn about it and any fellow classmates who want a video review. So starting with elements. Easy first episode. What are the 3 elements you need for a contract? You need mutual assent, consideration, and offer and acceptance. Mutual assent means both parties have to agree. Consideration means that there has to be something that both parties are getting. Can't just be a gift. Me saying I'm going to give you something. I have to get something in return. Offer and acceptance. One party has to make an offer. The other party has to accept it. There's the baseline. We'll expand from there. So let's talk about mutual assent. Mutual assent is when both parties agree to the contract and it's backed by consideration and the parties agree to bargain. So they're both agreeing to do the same thing. We have some relevant law there with the restatements, which of course you can go over. You'll want to look at restatements 17, 18, and 19 when you want to talk about mutual assent. Talking about assent, it can be made partially or fully by written or spoken word. A party's conduct does not constitute a manifestation of assent unless such conduct would give the other party reason to believe that it asserts assent. What this means is just because what you're doing looks like you're about to agree to the contract, it has to be reasonable that the other party would think you're about to agree to the contract. So just because the other party's walking up to come talk to you, that's not enough. Conduct of a party may manifest assent even if it's not meant to. These cases are avoidable by fraud, mistake, and duress. And then finally, consideration, something given, whether money, a return promise, or forbearance by the promisee to the promisor. That's how you have consideration. A gift is different. It's promise under restatement 71 or 218, and that has no consideration. So only one party is benefiting from it. So there's the quick overview of those, and we're moving on. Good faith. This is a short one. You have to negotiate in good faith. You can't commit fraud, or else it's not going to be valid. Yep, there you go. Good faith. All right, we're going up higher to acceptance. So acceptance means you're consenting or undertaking something offered. Performance equals acceptance. So there's two different ways to accept a contract. There's promise-based acceptance, and then there's conduct-based acceptance. So for example, if I say, if you cross the Brooklyn Bridge, I'll pay you $100. Once you start crossing the Brooklyn Bridge, you've accepted my offer. Even if I don't know that you've started crossing the Brooklyn Bridge, but I can't revoke my offer. The other way to accept is if I say, I promise to sell you my book in exchange for $100, and you say, I promise to give you that $100 in exchange for your book. Now we've exchanged promises. It's acceptance. It's enforceable. So that's the difference. Now, in terms of contract law, there are a few different rules under acceptance and how that acceptance has to look with a contract. The first is a mirror image rule. So in a contract, we have lots of terms. The mirror image rule says that the two contracts have to mirror each other. They have to be the same or else it's not a valid contract. UCC 2207, which I'm going to do a whole separate video about, allows differences in the contract. Another common law rule, something not under the Uniform Commercial Code, is the last shot doctrine down here. That means that whoever gives the last contract, that's the binding contract. So if I offer you one contract, you send me another one that has changed some terms, and I still accept that, now we have a contract and it's your terms that are binding, not mine, because you had the last shot. UCC 2207 disagrees with that and gets rid of it. So we'll do more about that in a bit. So before we do that, we're going to look at, gotta move it over here, answering the offer. You can do more than just accept, you can counter offer. Now, counter offering does not qualify as accepting if you are changing a material element. So if I offer my book for $100, You say, that's not worth it. I want your book for $75. You have now terminated your ability to accept. So I could say, no deal. In fact, I'm not selling you my book at all. You've lost your ability to accept because it's a material alteration of the price. If it's not material, like if you have a long contract and you say, well, actually, we want the contract to just be a little bit different, but it's not material, then you still have the power of acceptance because it wasn't a material alteration. You can also reject it. You can just refuse the offer. Once you refuse the offer, you lose the right of acceptance. You can't say, no, never mind, I want it. You've lost that. Now, if you say, no, never mind, I want it, and I choose to give it to you, that's my choice, but you can't force me to. I'm not required to. And then revocation. If I offer, revocation, somewhere there. If I offer to sell you my book, and you haven't yet accepted, I could say, never mind, I don't want to sell you my book. And I'm fully in my right to do that. You lose your power of acceptance. There's one exception to that, though. That's if there's consideration. So if I say, I'll sell you my book for $100, and you have this contract open for 1 week if you pay me $1. Then if you agree to that and said, yes, I'll pay you $1 to keep the option open for 1 week, I cannot revoke until that week is up. Doesn't matter if you actually pay me the $1, there's now consideration because the promise that you'll pay me $1 creates consideration whether or not you've actually paid me the $1. We get some weird cases where stuff like that happens, but that's the different forms of acceptance. Now we'll go into next episode will be qualified acceptance and the battle of the forms. So Battle of the Forms, a little bit more complicated, so we're going to need to read it off the board. Here it is. Sorry, my handwriting's so terrible. Battle of the Forms are contractual disputes when different writings are exchanged by the parties to make a contract. It's designed to figure out the terms of the contract when the forms don't mesh. So this is like how we were talking about the mirror image rule before. The contract doesn't match. So what are we going to do? Do we just get rid of it? Is there no contract? Well, this is what we have to look for. We have to look for mutual assent, an offer, and consideration. If the forms differ, but both parties performed as if there was a contract, then there is a contract. Usually. That means that they still have to continue under what they're doing. So like if they learn that there was a difference a year later, there's still a contract, the contract isn't void. If the court finds that there is no contract, the issue is over. So if they actually find that there's no contract, that's the end of it. But if there is a contract, then we use UCC 2207 or the mirror image rule. We talked about the mirror image rule. We're going to move to UCC 2207, one of the more confusing things. But here we go. UCC 2207. The way that we talk about contracts that differ. Oh, let me get this lined up. Contracts that differ. That's not the mirror image rule. So UCC 2207 makes a difference between non-material additions and material additions. Non-material additions are where both parties are merchants and the offer has not limited the offer to the original terms, and the offer's silence on the issue is treated as acceptance. So if party 1 gives the contract and party 2 sends back the contract with a non-material addition, then that is valid, that is binding, so that's bound. If it is a material addition, then it requires the other party's assent. They have to agree to it. So if I send you the contract, you materially alter it, send it back to me, that's not binding. Now there's a difference between additional terms and different terms. If it's an additional term, so if it's a term that was not addressed to the contract and you add it, something like we can't sue at trial, instead we have to go to arbitration thing, that's additional. So we apply UCC 2207. If it's different, so if it does something like change the price, change the delivery, that directly contradicts with something that I have in my contract, then there are actually 3 ways to look at that because UCC 2207 doesn't mention different terms, just additional ones. So 3 ways to look at that are 1, just UCC 2207, in which case we say it's material because it differentiates and we get rid of it. My contract is the one that we follow, yours we get rid of. There's also the knockout rule. The knockout rule means that the 2 different terms, my term and yours, knock each other out, and we just use a base term under the UCC. The UCC has a lot of general contracts terms that can be applied in any contract that doesn't already have them. So knockout rule, they both get knocked out. The last one is called the dropout rule. The dropout rule can also be called the first shot doctrine. It basically says, because my contract was there first, we follow its rules. So we drop your material alteration, your different term, and we use mine instead. So those are the three different ways that we can address different terms. So that's the UCC 2207 in a nutshell. It's a little complicated, but that's contract law. Next, we're going to talk about some liability. All right, we are now talking about this way up here, liability in absence of a bargain for exchange. So let's zoom it in there a bit. So option contracts are offers which the offeree could delay accepting without losing the power of acceptance, even if the offerer attempts to revoke. It requires consideration. This is like the situation I said before where I'd sell a book to you, but you have to pay me $1 to keep that option open for a week. Promising to pay the $1, it's now open, I can't revoke. Next, reliance on a gratuitous promise. A promise to do or not do something is made without the expectation of consideration, not a bargain for exchange. So if I promise to give you $1,000, and in reliance on that promise, you do something that costs you $1,000, I could still be bound to follow through with that because you relied on my promise. The last one is principle of restitution, relief for unjust enrichment. So unjust enrichment, it's meant to prevent a party from retaining a benefit conferred on that party if it would be unjust for the party to retain that benefit. So this is if somebody scams you, if it would be wrong for them to keep the amount they made. Restitution gives that money to the person who was scammed. That's the idea of liability in absence of a bargain for exchange. This is when we don't actually have a contract. So there we go. Next, we're moving to promissory estoppel. So promissory estoppel. What is promissory estoppel? What does it do? Promissory estoppel makes enforceable a definite promise that is not otherwise enforceable under contract law. So this means we don't have a contract. We have a promise. But that promise is still enforceable. Why? So this can be enforced on reliance. This is like what I talked about in the last video, where you rely on my promise to go do something, and you rely on it specifically to your detriment. Because of that, I can then be forced to follow through on the promise. Next, reliance on the basis of a contractual obligation. So this is, you're still contractually obligated to do something, you rely on it, you go forward, I still got to pay you for it. Applies to non-commercial transactions with some exceptions such as employment benefits or pension cases, and there's no consideration. So there are some elements that we need for this. There has to be a clear and definitive promise by the promisor. The promisee must have reasonably relied on the contract, and detriments of a definitive and substantial nature must be incurred in reliance of the promise. Somebody needs to have actually suffered because of this. If you were just minorly inconvenienced because I made a promise, like I made a promise to, I don't know, walk your dog, and the dog doesn't get walked, but that's really not a huge deal. The dog still ran around the house and didn't damage anything. Like that's if you didn't suffer any material damages, that's all. But of course, if you suffered, because we all love dogs. If you suffer material damages, I would have to pay for that. But assuming you did. Remedies. There are a few different remedies, ways that you can get back on this. Let's make sure that we're following my finger this time. Courts limit the promisee's remedy to what justice requires. So this puts the promisee in the same position they would be were before the promise. So it's not like you're getting $1 million for a hangnail. It's not like one of those situations. It's, if I didn't make the promise to give you this amount, where would you be? And then we get you to that level. So that's promissory estoppel. We're going to keep moving down the board because the contract final is in 3 days, and we got to study. All right, we're still moving forward. I just watched my first video and I hope that my audio hasn't been doing that odd thing the entire time. So I'm going to try to face the camera more and keep things in my background more. So we're changing things up. Anyway, UCC restatement versus, or UCC versus the restatement versus the common law. So yeah, when talking about contracts, what are the differences here? Well, the UCC Article 2 deals with the transaction of goods. Some rules are mandatory, some rules are default, and some are enabling. Enabling rules would be something like speeding, where you can go up to the speed limit, but if you go over, that's when you're pulled over. So that's enabling. You can go, there's like room in the contract, but you can go up to it. Anyway, common law and restatement say that if certain hoops are not jumped through, they will not recognize the contract, which is oh so fun. So the UCC does not follow the mirror image rule under common law, which is what we talked about before, be the mirror image rule, while the restatements and common law follow that. And then we have some defenses against the enforcement of a contract. Those are statute of frauds, which we'll go over in a bit, duress, misrepresentation, unconscionability, mistake, and impracticability. We will go over each of those in turn. But congratulations, we made it through 4 of these little things. And we're going to continue on. Let's talk about one of the big ones, the statute of frauds. What is the statute of frauds? Well, they're statutes meant to prevent fraud. There we go. That's the end of the episode. Of course, I'm joking. There's a lot more than just fraud. The statute of fraud basically lays out 6 different types of contracts that have to be done in writing. So when you make an oral contract, so I promise to sell you my book, you say you'll give me $100 for it. We now have a contract. It may not be on paper, but we have a contract and it is enforceable. But the statute of frauds lays out contracts that you can't just make an oral contract, it has to be in writing. So what are these 6 different types of contracts and why? Well, let's go through them one at a time. Contracts for the sale of goods over $500. This is governed by UCC 2201. Well, why? It's because we're dealing with a lot of money. The thing with oral contracts is this might be shocking. When taken to court, people can just lie. That's a little difficult. So when you're dealing with things over $500, you really need more than just an oral promise. You need more than just a, well, I promise to pay you, $1,000, and then you finish and like, actually I said $750. It's really best to have something like that in writing. Number 2, contracts that cannot be performed in 1 year. It's a little hard to remember what you said a year ago. If there's any chance that it can't be performed in 1 year. And if both parties figure that, so both parties know that it will not be performed in 1 year, it has to be in writing. If it's unforeseeable, such as if one party gets really sick, you can have a little bit of leeway there. But if both parties, like if you're promising to build a house, which would probably be in the 500 one as well, if that's going to take over a year, you really need a written contract. You can't just make an oral promise. All right, moving on to number 3. Contracts involving the transfer of interest in real estate or real property. Here's the thing about property law. It's complicated. The way that you're transferring that property, the way that you word the transfer really, really matters. And if you don't word it right, it can completely change who gets access to that property, whether or not the person you transferred it to, whether their kids will have access or their spouse if they die. So it really needs to be in writing. Next, contract, I just said that one, but the exception for number 3 is if the party has relied on the contract and has suffered a detriment. So there you go. That's an exception. Number 4, contracts answering for the debt of another person, or a suretyship contract, or a grantor. So this is if I am answering for like my younger brother's debt. That needs to be in writing. I can't just say, I'll take his debt, because what's stopping him from saying, oh, my brother promised to take care of my debt? Not really, that'd be an oral promise, not binding. But it should be in writing. An exception is if the promisor's main purpose in making the promise is to further his or her own economic advantage rather than benefit the other person. So if you're not being ultras, it can be binding. Yeah, sweet. That's pretty cool. All right, number 5, contracts by executor or admin administration to answer for the duty of his decedent. So promises for the duty of the decedent. So if somebody dies and you have to answer for their duties, all of those contracts have to be in writing. Here's something that's shocking. Someone who's dead can't really talk. So you gotta answer for that in writing. All right, so 6, contracts in consideration of marriage. Now, the exception for that is contracts that contain a mutual promise to marry do not fall within the statute of frauds. So this isn't promising somebody to marry them. These are contracts in consideration of marriage. So contracts that you're making if a marriage is going to happen, those are under the statute of frauds. All right, so now let's say we're analyzing the statute of frauds. I've got to go lower here because I wrote on this entire whiteboard, and I'm just the wrong height to be able to see everything at once. So, analyzing the statute of frauds. Here are the questions you asked. 1, is the contract in the statute of frauds and required to be in writing? 2, if it is there sufficient writing to comply with the writing requirements? Multiple writings can be used. So even if the one contract isn't enough, you can put multiple things, or you could say multiple interactions between the parties that can fulfill the writing requirement. And if no, can the contract be enforced by an exception, such as part or substantial performance or promissory estoppel? We went over promissory estoppel, but the part or substantial performance could come into play if we have something like number 2 with the house. So say you promised to build a house, you thought you could do it in under a year, and you're almost finished. And they're like, oh wait, there's no contract under the statute of frauds. The person who paid to have the house built can't be like, sweet, there's no contract. I don't have to pay you for the work you've done. No, they still have to pay you because there's been substantial performance. It's just, it needs to be in writing, and it's a lot easier if it's in writing, and you may not get as much as you deserved had it been in writing, but you can still get something. It'd still be enforceable. It's just more difficult. So there you go. That's the long and short of statute of frauds. If you have any questions or if I got anything wrong, slap that in the comments. I know this was a big one. So there we go. All right, still moving on, doing a lot. We've moved to principles of interpretation. So there are different ways that courts interpret contracts, especially when there are terms that the parties argue what those terms actually mean. Say you have a case where 2 parties argue about what the term recording meant, when one party has the right to all recordings of the other party's music. The singer argues that recording only meant like vinyl records because that's all that existed back then. And the other party says any recording, any pre-recording. Bam, you have to look at the different types of interpretation, figure out what it's talking about. That was taken from a practice problem. Here we go. So the first is subjective theory. This theory honestly doesn't come up as much, and here's why. It's about what did the parties mean? What did they intend? What was in their mind? Now here's something that's a little difficult. The court can't actually look into people's minds. They sort of just have to take their word for it. The problem with that is that parties can, shockingly, lie. So if that music artist was like, yeah, we totally only meant the physical vinyl records, that's all. Everything else was supposed to go to me. And the music company can be like, no, we meant anything pre-recorded at all. Well, I mean, do we really know that? They could be telling the truth. They could not be. It's a little hard. And looking for evidence of it, of what was in their head, is a little hard to find. So, meh. Okay, but then we move to the objective approach. So what would a reasonable person have meant? At the time of the contract, what would a reasonable person mean when they say recorded? Words and conduct, that's what they look at. Intentions are irrelevant. That's not what we're looking for. We're just looking for the words and the conduct. That's the objective approach. The issue is it can come across as a little harsh sometimes. Intentions, they do matter a bit. I mean, that's what a contract is for, your intentions. But that's the objective approach. That's why we have the modified objective approach. That is where it's slightly objective, but it adds evidence from intentions. So you're allowed to bring in the evidence of what you intended, but it still also looks at the evidence of objective and moves it all together. Another important thing to talk about here is the restatement 201, or restatement 201. If the parties had different intentions but didn't know, then there is no contract. So Restatement 2201 would say if those intentions were different, then the contract is void. This is a lot like the doctrine of mistake, which we'll talk about a little later. But that's what would strike away a contract, say that there was never a contract in the first place. So there you go. That's the principle of interpretation. That's a good one. I don't know why I didn't do this before, but I'm now in a chair, so it shouldn't be as shaky. Good, because we're on adhesion contracts. So adhesion contracts are standard form contracts prepared by one party, not negotiable. It's a take it or leave it contract. This can be something like you're renting an apartment from a big business, a big company, and they pre-make the lease. You're not negotiating that lease. You either sign it and get the property, or you don't and you don't get the property. There's no negotiation. So that is a standard form contract. There are three elements that go into it, or three factors that go into a standard form contract. The use of standard forms. I know, shocker. Inequality of bargaining power. Only one party has the bargaining power. They gave you the contract. You can't say no. Absence of choice for them to, other than for them to accept or reject. That's all you can do. You can accept the contract or you can reject it. Now here's the thing. Even if you don't read that contract, which you should still do, you're still bound to everything in it, even if you're surprised by it. Here's why. Reasonable expectation. When in an adhesion contract, any term is included but not negotiated about is still considered binding due to the reasonable expectation of the non-drafting party. So the courts assume that you know what should be in a leasing contract. Because of that, any term that is reasonably in a leasing contract, you're bound, even if you didn't see it your first read through. There are some exceptions to this. It has to be reasonable. For example, there's a case where a lady, I can't remember exactly what she was doing. It said about a pregnancy, but during the signing, she had a contract was put in front of her that was an arbitration clause. So she wouldn't be allowed to sue if they did something wrong. Well, they did something wrong. And the arbitration clause was found to not fall under a reasonable expectation because when you're in the hospital, you don't expect them to give you an arbitration clause to sign. You expect things about waivers, saying that they're allowed to operate on you, waivers of liability, not arbitration clauses. So that's the thing with a reasonable expectation. That's the keyword, reasonable. But another keyword thing you should remember, read your contracts. So there you go. And we're moving on. All right, we got another big one, the parole evidence rule. This is a fun one. So this is the rule that prohibits introducing oral or written evidence that contradicts the final written agreement of a contract. That means, as far as some judges look at it, the contract is the final and complete agreement by the two parties. You can't introduce anything else to add on to it. What is in the contract is it. That's all. Some judges think that. Others allow you to enter parole evidence. Let's see when. So parole evidence is evidence that is external to the contract, offered to explain the terms. The purpose is that parties to an agreement will include all of their terms in a written contract that were not intended to be part of the final agreement. So they'll include it all. If it wasn't intended to be part of the final agreement, it won't be there. So what's the classical approach? The classical approach looks at a complete integration or full integration. It says that the writing has been adopted by the parties as the final and complete statement of terms. Nothing else can be added. You might be able to look at things to explain certain terms, but if you have an employment contract that doesn't mention that you're allowed to work from home, then you're not allowed to work from home. It doesn't matter what the other party said to you that you could. It's not in your final contract. So you can't enter in evidence of it unless it explains some term in your contract, which it probably doesn't because there's nothing in there about you working from home. So that seems a little bit unfair. So now we talk about partially integrated agreement. This is where the writing has been adopted by the parties as the final but incomplete statement of terms. So judges under this view say that you can bring outside evidence to show that there are terms that weren't necessarily included in the original contract. Now your 1 to 2 day work from home can be valid. Woot woot. So now let's talk about the modern approach. Courts should take a broad look at the relevant evidence in determining what the parties meant, and whether or not they meant for their writing to be the final and complete statement of the agreement. Cool. So we found a happy median where courts aren't throwing it all out, but they're also not taking in things that were moved during bargaining. Because it's true, you make offers that don't end up being the final part of the contract. Say I offer to sell you my water bottle and my computer for $2,000, and you say, you know what, we don't want the computer, we just want the water bottle for $25, and we agree. Well, now that whole computer thing is not relevant to bring in, even if you wanted it to be there. So there we go. May not have been the best example, but here we are. Exceptions to the parole evidence rule is the explanatory evidence or interpretation exception. Not to modify, but explain, clarification. So this is under the full integration. Under the full integration, you can still explain terms using parole evidence. Here we have subsequent agreements or modifications. It's appropriate to allow parole evidence for the purpose of modification to an agreement. You're going to change the agreement. You're allowed to enter in evidence of that modification if the agreement was modified. Fraud. If there was fraud, you can enter that in as evidence. They're not going to force a party that was defrauded to not enter in evidence of that fraud. That'd be strange. Finally, collateral agreement exception. If it's a collateral agreement, you can put in evidence of that, despite it not actually being in the contract. So those are just some things about the parole evidence rule. It's important to note that two different judges disagree, and that's good to know for the final. I don't remember the names off the top of my head, but it's in the outline. So yeah, but partial versus complete integration is the big thing to get out of here, is whether or not the parole evidence can be used to just explain or put into context a certain term, or whether it can be added in. So that's the big difference. So there you go. That's the parole evidence rule, and we'll move on. All right, so here we have implied terms. Implied terms are terms that were not listed in the contract, but it's implied that they're there. So just because you didn't agree to it doesn't mean that you're not bound by them. Those would be good faith and the obligation to act reasonable. You can't negotiate in bad faith just because you didn't promise to negotiate in good faith. You have to always negotiate in good faith. You can't cheat the other party because you didn't promise not to cheat them. It's assumed you're not going to cheat them. All right, so rational or implied terms, these are terms that are not listed in the agreement, but they are essential to the deal that the parties have actually made, so they're still in the contract. Or the implied doctrine of good faith. We went over good faith before. So you have these implied terms. You can't cheat people. You got to follow it, even if it's not written in the actual contract. And we'll move on. All right, so what do you do when you're avoiding enforcement? A contract defense. This assumes that there's an ordinary requirement for contract formation that's already been met, but one of the parties wishes to avoid obligation of the contract. A valid defense to enforceability renders a contract unenforceable. So what are those defenses, and what are the excuses? So one of the excuses is mistake. If there's a mutual mistake, the contract is voidable by the party that's adversely affected unless they have the burden of bearing that risk under Restatement 154, which I'll go over to in a moment. If it's a unilateral mistake, it's voidable under 154 unless the party bears the risk. So what are other examples of something that voids the contract before we go to 154? That's a change in circumstances. If circumstances change such that performance is impossible or impracticable, or the purpose has been frustrated, then the contract is not enforceable. So what's the difference? Impossible means exactly what it sounds like. It's impossible. Something like I promised to provide a music place for you to play, then it burns down. It's impossible for me to provide that place for you to play. So I'm not bound by that. Impracticable could be a change in circumstances that was not foreseen. For example, I promise to use rubble from your estate and pay you for it. You promise to use all my rubble. Figure out that most of your rubble is buried deep underwater and I can't really get to it, or it costs me way more to get to it. I don't have to follow through on using all my rubble from your place because there's been a change in circumstances that wasn't foreseen. And it's impracticable that I do that. It would cost me way more. Frustration. This means that the purpose of the contract is frustrated. So this is something as simple as the reason that we made the agreement is no longer possible, so it can still be escaped. So what is Restatement 154? So Restatement 154 says that a party bears the burden of the risk to the contract if the risk is allocated to them in the contract. The contract just says if this happens, you bear the risk. If they are aware of their limited knowledge, but treat that knowledge as sufficient, such as if they're selling something, they know they don't know the details about the price, but they're like, well, I know enough, and they sell it. Well, they bear the risk if they price that thing way too low. Or if the circumstances are reasonable according to the court. This is one of those great times when the court just says, if we feel like it. If they feel like it, the other party can be responsible. That's awesome. So there we go. And next episode we'll do damages and remedies. So there you go. Damages and remedies. Somebody's violated the contract. Well, what can you get? Well, you can get expectation damages. This puts the party in the same position they would have been had the contract been performed. This is pretty simple. You lost this much money, you get that much money back, you're in the same position you would have been in. Then we have, we're going to skip that one because I can't read it. Reliance damages. This is return to where they would have been without relying on the promise. So you spent $1,000 relying on my promise. I gotta give that back to you. Or if you did something even more worrying and you sold your house in reliance on my promise, I have to pay you back for that, whatever you lost. So there we go. So this is actually restitution. Restitution. So this strips the breaching party from any benefit. If one party is cheating the other party and they save a bunch of money and they're like, well, yeah, you can sue us, but we won't have to pay you that much. It's going to strip them of that ill-gotten gain. And then specific performance. Courts are a little hesitant to grant this one, but it's basically just they have to perform the contract as promised. The issue with specific performance is you would have to make sure that the party is doing that in good faith. They've already breached the contract. So forcing a party that has already breached a contract to then go and perform that contract can be difficult, to say the least. And the court doesn't like to put itself in that sort of position where they have to constantly monitor that party to make sure that they are completing the contract. So specific performance, not always going to get it. Sometimes we will if there's no other way to make the party whole, such as if the other party, the breaching party, promised to sell them like a one-of-a-kind car. So you really don't get anything equivalent unless you have specific performance. So there we go. That's damages. Next, we are moving up to limitations on recovery. So there we go. Limitations on recovery. All the way up here. This is foreseeability. If the thing was not foreseeable, you can't recover. This has to be reasonable foreseeability. So, for example, again, like the music house burns down. It's impossible that I give you the place to sing. It's not foreseeable. Now, some places they do say that things like that should be included in the contract, but it has to be foreseeable that this thing can happen. That it's not an act of God that nobody expected. It's like a meteor fell on it. Yeah, okay. Now what? So it has to be foreseeable. Next, certainty. A party can only recover amount of damages that can be certainly proven by law. You can't say, man, he stepped on my foot. He owes me $1 million. Now, of course, that's a tort. That's not a contract. But the point is you have to prove that you actually lost the money. You can't just say, oh, I want this much money. Right. Okay, next. Causation. The defendant's break of the contract must have actually caused the plaintiff's loss or damages. If I didn't cause your damages, I don't have to pay you. I didn't do anything. So there we go. That's the limitations of damages. Next, we're going to talk about the consequences of non-performance. So there we go. Hope contracts are treating you well. All right, we're nearing the end with consequences of non-performance. So what happens when you don't perform? So there are express conditions in a contract. And in the event that, so this is an event that must occur before the party is subject to the obligations of liability. If express conditions are not met, a party can walk away. So if it's saying, you give me your book, I'll give you $100. You never give me your book, I never have to give you $100. So that's an express condition. But let's go over the different types of breach. A material breach. A material breach is the failure to perform a significant obligation that allows the other party to sue for damages. Now, the other party does not have to say that the contract is now void. They can choose to treat the material breach as a partial breach and hope that the other party will make it right. But a material breach can be something like a construction company knocks over the house they were building. Well, you've just sort of materially breached because, and then they don't pay for it, they don't fix it. Yeah, that's a material breach. Partial breach. This is a breach that is not significant. It does not discharge the non-breaching party. They must continue to perform their obligations under the contract. This is a more minor breach. The other party can't be like, oh man, you delivered a day late. That's a material breach. We're done. I'm suing. Like, no. Very rarely is that gonna happen. They're still bound. Now, a total breach is a material breach that has not been cured in a reasonable time. At that point, that party can get damages. And there's really no fixing it at that point. So then we have a substantial performance, which amounts to a partial breach for which the breaching party must answer in damages, but does not discharge the party as it would be in case of a total breach. So this is like how material breach becomes total breach, partial breach becomes substantial performance. They need to continue to perform. But if they get substantial performance despite the partial breach, it's not a full end to the contract. So there we go. There is the consequences of non-performance. And next we're going to move to the rights and duties of third parties, and that'll end it. So here we go. All right, welcome to the final one. It's a little in the corner here, but the rights and duties of third parties. So a third party can be a beneficiary, an assignee, or a delegate. So here are the questions to ask when you have a third party, because normally third parties can't sue. If the third party, he's not in the contract, he might be indirectly benefited, but he doesn't have the right to sue. An example would be if my neighbor promised to get their lawn cut, and then the lawn cutting company didn't come in, and I'm like, wow, this makes my house look ugly next to this house that's ugly. So I want to sue. No, I can't sue. So when can they? So we first ask whether or not the third party has standing. That has sub-questions, as it must. Did both parties intend for this person to be a beneficiary? Did one party intend to be a beneficiary? Do they have standing? So we just go over those. Did the two parties in the contract intend that this third party actually get anything? Or are they just an unwitting beneficiary? If they're unwitting, they can't sue. But if they were meant to be included, then they might have some standing. All right, so 2, if they have standing, how has the breach harmed them? Has it harmed them? How has it harmed the benefit the other party was interested in? If it hasn't harmed them, can't sue, nothing really to sue for. So, third party beneficiary, a non-party to the contract who receives the benefits of the contract and who may possess the right to sue under the contract. So there's 3 tests for standing. We were talking about standing. Here are the tests. 1, dual interest of the promisor and the promisee for the contract to benefit the third party. Both parties must have the same intent to provide a benefit to the third party. So both the offeror and the offeree have to have intended that third party to benefit somehow. One party can't be like, oh yeah, my buddy's going to benefit from this. They both have to intend that. 2. Intent of the promisee to confer a benefit on the third party. Only the promisee intended to confer a benefit. 3. Intent of the promisee to confer a benefit coupled with the promisor's reason to know that the promisee's only promise intended to confer to the beneficiary. I know that's a little bit long, but that's another one where it's like a party intended it to go to this third party. This third party has to have been involved in the contract. All right, assignment. This is not a contract, but rather a present transfer of contractual rights. So this is where the obligatee becomes the assigner. The third party becomes the assignee. Any rights under the contract may be assigned to a third party. Method of assignment: assigner needs only manifest present intent to fully transfer benefits to the third party. Assignee must accept. So I'm currently benefiting from the contract, transferring those benefits to a third party. They need to accept, and then it goes to them. Then they can have standing to sue. So then we have the exceptions to assignment. Any rights under existing contract may be assigned to the third party unless the particular assignment would materially change the obligator's duty, increase the obligator's contractual burden or risk, impair the obligator's chance to obtain a return performance, reduce the value of the assignment, and reduce the value of the assignment. All right, so now we move to the last one, delegation. So there we have the transfer from one party to a third party of the obligation of performance under the contract. So now another party has to perform. An obligator under the contract may arrange for a third party to perform the obligatee's duties. So I promise to do something, I'm getting someone else to fulfill that promise. The third party may be delegated the duty to perform under the contract. Any duties under the contract may be delegated to the third party unless no other party has substantial interest in the original party's performance. So this is just, I have to perform for you to do something. This could be a contractor saying, well, I can't build the house, but I'm going to have somebody else do it. They can delegate. Now some exceptions. A duty is not delegatable if the contract clearly states a specific person must perform. So if it says that I specifically have to do it, I specifically have to do it. The performance requires substantial personal skill and discretion. I can't have somebody who's not qualified do it. And there are other circumstances which it is clear that the identity of the person rendering performance is material and the obligation and bargains for exchange. So this is, say you have the best doctor in the world who would do a surgery. You can't trade off with some brand new med school graduate and then the family have to pay the same price because the person who's doing it is it matters. And with this being my longest video, we get my done. We're done with my very long contract thing. Hope you enjoyed. If I got anything wrong in any of the episodes, let me know. I know this one was pretty confusing. It's because I've been talking through all of it. I was a little rambly. Just ask questions in the comments and I'll help you out. Peace.